In international human rights litigation, the severity of a crime does not guarantee a hearing. Even in cases involving just cogence violations, like torture, if a complainant cannot establish formal jurisdiction, the tribunal locks them out. The United Nations Committee Against Torture, operating under Article 22 of the Convention, serves as a mechanism for individuals to hold states accountable, but it operates under strict procedural mandates. Before the committee will examine a single piece of evidence regarding the substantive abuses, the complainant must establish a strict prima facie case for admissibility. We can examine this exact threshold through the live case study of Smedema versus the Netherlands, currently directed toward the committee in Geneva. If Smedema fails to satisfy these procedural requirements, the state-sanctioned abuses he alleges remain legally insulated from international review. The strategy of the Smedema communication is to prove a dual-phase breach. The legal team must demonstrate that the Dutch state is both the direct architect of the original abuse and the ongoing structural obstacle preventing any domestic redress. The admissibility phase is the primary legal battleground. This is where a respondent state will focus its efforts to kill a claim before the facts are ever weighed. To bypass the state's defenses, the communication maps the exact legal architecture required to neutralize massive temporal barriers and prove the systemic ineffectiveness of the Dutch legal system. Unlocking this admissibility gateway tests whether international law possesses the mechanical capability to pierce a sophisticated wall of domestic state impunity. The mechanical assessment of Smedema's jurisdictional competence begins with the most straightforward requirements. This animated matrix tracks the admissibility criteria. Smedema establishes ratio personae, direct victim standing, by filing on his own behalf. The acts occurred within Dutch territory, fulfilling the ratione loci requirement for state responsibility. The communication also confirms no other international procedures are pending, satisfying the non-duplication rule. But the assessment halts at the primary structural obstacle, time. This is the ratione temporis challenge. The foundational crimes, clandestine chemical abuse and electroshock conditioning, occurred in the 1970s, placing them behind a massive temporal barrier. To bypass a 50-year statute of limitations, the communication deploys the continuous violation doctrine. Under this doctrine, the treaty violation is not limited to the historical act of physical abuse. The violation is the perpetual, uninterrupted state of non-redress maintained by the authorities. Smedema's communication documents a continuous chain of state refusal to investigate, beginning with a 2004 police order obstructing a report, continuing through the present decade. The definitive anchor is the November 13, 2025 Ministry of Justice rejection, reference 6155331. This document serves as the contemporary manifestation of the breach. The ongoing refusal to provide an impartial investigation pulls a 50-year-old crime into the present. It is an active breach of the Convention today, which legally neutralizes the temporal limits. The next hurdle is the exhaustion of domestic remedies. International law requires a complainant to litigate through the highest national courts before approaching the UN. This rule assumes the domestic courts are accessible and functional. When a state operates in bad faith, forcing a complainant to exhaust remedies simply traps them in endless, futile litigation. This highlighted text shows the crucial exception clause in Article 22, paragraph 5b. The committee waives the exhaustion requirement if domestic remedies are unreasonably prolonged or unlikely to bring effective relief. Smedema argues that the Dutch legal framework is an engineered closed loop, specifically designed to protect the state from its obligation to investigate under Article 12. The evidence shows a 20-year chronology of futility. It starts in 2004, when the Ministry of Justice expressly forbade police from filing an official process verbal for Smedema's complaints. In 2005, the Court of Appeal rejected an Article 12 procedure, entirely ignoring a submitted document containing explicit spousal consent for an investigation. This cycle culminated in November 2025. Categorical rejections by the ministry and a non-substantive dismissal by the National Ombudsman trigger the finality of this closed loop. Because the highest administrative and judicial authorities have issued definitive refusals while ignoring evidentiary annexes, any further litigation is impossible. It is a legal black hole. By proving the domestic route is a verified dead end, the complainant satisfies the Article 22 5b waiver, cleanly removing the final standard procedural barrier. The question is how a sophisticated Western legal system actively maintains this black hole without drawing international scrutiny for overt autocratic behavior. The communication details a tactic of institutional gaslighting. The state weaponizes administrative and psychiatric tools to completely bypass the judiciary. This network map visualizes the complainant's isolation. The first tool is the cordon sanitaire. Since 2004, hundreds of lawyers have refused representation. This state-induced total failure of the legal market physically blocks the complainant's access to counsel. The second tool is the secret curatelle, or secret guardianship. This is a clandestine administrative status imposed without due process that legally categorizes a citizen as incompetent. The evidentiary proof for this status relies on documented secret marriage signatures, where Ministry of Justice officials were required to covertly sign off on the complainant's personal affairs. To justify this, the state relies on foundational clinical labeling from 1975. By diagnosing the complainant as delusional, officials preemptively invalidated his warnings of chemical abuse. This clinical labeling operates as a jurisdictional shield. The state uses a medical designation to evade its strict just cogence obligations to investigate torture under Articles 1 and 16. These overlapping mechanisms strip the complainant of legal standing entirely. When a citizen is deemed legally invisible, their complaints are summarily dismissed without ever reaching a judge on the merits. The evidence of administrative disappearance and tactical labeling forms the basis of the argument that domestic relief is structurally impossible, satisfying the Article 22 requirement. With the mechanisms of state obstruction exposed, the macro admissibility argument is complete. The continuous violation doctrine and the documentation of administrative disappearance provide the legal logic to address the gate. The structural barriers constructed by the state align with the exceptions provided in the Convention. With these arguments established, the procedural path opens for the Committee Against Torture to address the substantive merits of the foundational crimes. But an admissibility finding can take years. To survive the pendency of the communication, the legal team introduces a final strategic layer, Rule 114 interim measures. Under Rule 114, the committee can demand a state party take immediate action to prevent irreparable harm to a vulnerable complainant during the international review. The urgency is acute. At age 77, Smedema faces cardiac distress tied directly to the original 1975 poisoning, compounded by severe financial destitution resulting from state-induced legal drain. The communication demands immediate interim relief. The establishment of an independent legal aid fund to bypass the cordon sanitaire, and an order compelling the monolithic state apparatus to unseal all intelligence and ministry files. Without immediate UN intervention to strip away these administrative barriers, the complainant remains trapped in enforced legal non-existence. In complex human rights litigation, securing justice does not begin with proving the torture occurred. It begins with legally dismantling the architecture of state impunity.